Sometimes you see a headline and you have to read it 3 times just to make sure the English language hasn't fundamentally changed overnight. You sit there staring at your screen thinking, there is no way they just said that out loud. Usually, when a government knows it's about to get smacked down by the Supreme Court, they at least have the decency to pretend they respect the process. They spin, they deflect, they say, we are confident in our legal arguments. But yesterday, the Trump administration decided to skip the pretense and just go straight for the jugular of the judicial system. If you missed it because you were busy living a normal life, U.S. Trade Representative Jamieson Greer went to the Atlantic Council on December 10th, literally less than 24 hours ago, and casually dropped a bomb that should terrify anyone who cares about checks and balances.
Cambodia's already reduced theirs. You mentioned India. I have a team over there right now as we speak in New Delhi working on this. There's resistance in India to certain row crops and other meats and products. They're, like you said, they're very difficult nut to crack. I agree with that 100%. But they've been quite forward-leaning. The type of offers they've been talking to us about have been the best we've ever received as a country. So I think that's a viable alternative market.
He was asked about the tariffs, specifically the tariffs that are currently hanging by a thread in the Supreme Court, the ones challenged in Learning Resources, Inc. versus Trump, the ones that legal experts have been screaming are an abuse of emergency powers. And Greer didn't flinch. He didn't give the standard lawyer answer. He looked the moderator in the eye and effectively said, it doesn't matter what the court decides. We have a backup plan. I want you to really pause and process the arrogance of that statement. We are talking about the highest court in the land potentially ruling that the President of the United States broke the law by using the International Emergency Economic Powers Act, IEEPA, to tax American consumers. A ruling like that is supposed to be the end of the line. It's supposed to be the referee blowing the whistle and saying, play over, you lose.
But Greer is telling us the game is rigged. He confirmed on the record that if the Supreme Court strikes down their authority, they are just going to swap out the paperwork and do it anyway. He called it using other tools and existing statutes to make sure there is, and I'm quoting him here, continuity of policy. Continuity of policy. It sounds so boring, doesn't it? It sounds like something you'd hear at a muted insurance seminar. But let's translate that from bureaucrat speak into reality. We are going to take your money, and there is absolutely nothing the Supreme Court can do to stop us. This isn't just a plan B. This is a mockery of the separation of powers. Think about the message this sends. They are telling the justices to their faces, go ahead, rule against us, strike down the IEEPA justification, write your scathing opinions. By the time the ink is dry, we will have already reimposed the exact same tariffs under Section 301 or Section 122 of the Trade Act, and will dare you to sue us all over again. It turns the Supreme Court into a minor speed bump. It treats the Constitution like a terms of service agreement you school past without reading so you can get to the part where you do whatever you want. And the wildest part? Greer was calm. He wasn't shouting. He wasn't sweating under the lights. He was treating the potential invalidation of federal law as a logistical nuisance, like a road closure on your morning commute. Oh, the Supreme Court closed the highway? No problem, we'll just take the side streets. We're still getting to your wallet. If you are watching this and feeling a knot in your stomach, good. You should be, because this isn't about trade deficits anymore. It isn't about whether you like tariffs or hate tariffs. This is about an executive branch that has looked at the one institution designed to check its power and said, you are irrelevant.
They are betting that you won't notice. They are betting that the media will get bogged down in the technical differences between Section 301 unfair trade practices and IEEPA emergency powers and miss the forest for the trees. They are counting on us being too exhausted to care that they just admitted in public that the legal reasoning doesn't matter, only the outcome does. Well, I'm not exhausted. I'm wide awake, and we are going to look at exactly what this backup plan is. Because if you think the current tariffs are a mess, wait until you see the legal Frankenstein they are stitching together to replace them. Let's actually pop the hood on this, because unless you're a trade lawyer or a masochist, you probably haven't spent your weekend reading the Trade Act of 1974. But you need to understand the mechanics of this con, because the how is just as terrifying as the what. First, we have to look at why they're scrambling for a backup plan in the first place. Why is Jamieson Greer, a guy who usually projects absolute confidence, suddenly talking about Plan B at a think tank event? It's because their current legal argument is built on sand, and they know it. Right now, the administration is using IEEPA, the International Emergency Economic Powers Act. This is a law designed for literal emergencies. We're talking about sanctioning terrorists, freezing the assets of rogue states like Iran or North Korea, or responding to an unusual and extraordinary threat to national security. It was written to give the president a loaded gun to use when the house is on fire. But Trump isn't using it to put out a fire. He's using it to remodel the kitchen.
He has declared a national emergency regarding the border and the drug trade. Real issues, sure, but he's using that declaration to impose broad, sweeping economic tariffs on everything. And that is exactly what the plaintiffs in Learning Resources Inc. versus Trump are pointing out. They are standing in front of the Supreme Court saying, you cannot use a national security emergency statute just because you want to rewrite tax policy. It's an overreach, so massive it makes executive orders look like polite suggestions. So, the administration sees the writing on the wall. They know there is a non-zero chance that a strict textualist Supreme Court looks at IEEPA and says, nice try, but no. Enter the backup plan. When Greer talks about other tools, he isn't pulling them out of thin air. He is referencing two specific zombie statutes from the 1970s that they are preparing to reanimate. And when you look at the fine print of these laws, the cynicism becomes overwhelming. The first tool in their shiny new toolbox is likely Section 301 of the Trade Act of 1974. Now, Section 301 is the heavy artillery. It allows the president to retaliate against foreign countries that engage in unfair trade practices. It sounds reasonable, right? If China steals our IP, we hit them with Section 301. That's how it's supposed to work. But here's the catch. Section 301 requires an investigation. By law, the USTR is supposed to investigate the practice, document the harm to U.S. commerce, hold hearings, and then decide on a remedy. It's a process. It takes time. It requires evidence. But Greer is suggesting they can just switch to it instantly.
Think about what that implies. If the Supreme Court strikes down the IEEPA tariffs on a Tuesday and the administration reimposes them under Section 301 on a Wednesday, they are admitting that the investigation is a farce. You can't conduct a comprehensive review of global trade practices in an afternoon. They're effectively saying, we have the verdict written, we just need to fill in the trial later. They are treating a legal requirement for evidence as a bureaucratic Save As button. File, Save As, Section 301 justification.docx. It gets worse. The second tool, and this is the one that should really keep you up at night, is Section 122. This is the Balance of Payments Authority. It's a relic. It was written for a time when the global economy looked completely different. Section 122 allows the president to impose tariffs if the United States has a large and serious balance of payments deficit. Basically, if we are bleeding too much cash to the rest of the world, the president can slam the brakes. But read the fine print. I have the statute right here. Section 122 has strict limits. It authorizes a surcharge of not more than 15%, and it says the measures should be temporary, specifically for a period not exceeding 150 days unless Congress extends it. 150 days. Does anyone really believe that Donald Trump or Jamieson Greer are planning a temporary 150-day tariff? Of course not. They're building a permanent tariff wall. So if they pivot to Section 122, they're going to have to break the law while they're using the law. They'll likely argue that the 150-day limit is flexible or that they can just renew it indefinitely, turning a temporary emergency stopgap into a permanent tax on the American consumer. They're playing three-card Monty with the United States Code.
Look at the shell game they are running on the American people. Under IEEPA, they claim the justification is national security emergency. If that fails, they switch to Section 301, and suddenly the justification is unfair trade practices. If that gets bogged down, they switch to Section 122, and suddenly the justification is balance of payments deficits. So which is it? Is it a security threat? Is it cheating? Or is it an accounting error? The answer is it doesn't matter. They don't care about the why. They have the what, the tariffs, and they are shopping for a why that sticks. It is result-oriented jurisprudence on steroids. They have decided the punishment, billions in taxes on you, and they are frantically searching through the dusty law books to find a crime that fits the sentence. And Greer's comments at the Atlantic Council confirm this. He didn't say, "We will review the law and follow the court's guidance." He said they have a plan to recreate the revenue. That is the tell. It's about the revenue. It's about the power. It is about maintaining the policy at all costs, regardless of what the Constitution or the Supreme Court or the plain text of the Trade Act actually says. And let's be honest about the timeline here. Even if they switch to a flimsy legal theory, what happens? Someone has to sue them. Again. Learning Resources or another company will have to file a new complaint. They will have to find a plaintiff with standing. They will have to file in the Court of International Trade. They will have to brief the case. They will have to argue it. Appeals, circuit courts. That takes years. By the time a court finally says, "Hey, you can't use Section 122 for a permanent tariff," the administration will have already collected the money. They will have already altered the supply chains. The damage will be baked in.
They are weaponizing the slowness of the judicial system against the rule of law. They know they can break things faster than the courts can fix them. And Greer is standing there, smiling, telling us exactly how they're going to do it. We need to zoom out, because if you think this is just about Jamieson Greer having a bad day at the office or a specific legal hiccup with Learning Resources, you are missing the forest for the trees. We have seen this movie before. We know exactly how it ends. This isn't an isolated incident of an administration trying to salvage a policy. This is a pattern of behavior. This is the defining architectural feature of the Trump trade doctrine. The outcome is fixed. The law is fluid. Go back to 2018. Do you remember the steel and aluminum tariffs? Do you remember the justification they used back then? They dusted off Section 232 of the Trade Expansion Act of 1962. That law allows for tariffs if imports threaten national security. National security. They looked the American people in the eye and argued with a straight face that importing steel from Canada was a threat to the national security of the United States. Canada, our NORAD partner, the country that has fought alongside us in every major conflict for a century. They labeled Canadian aluminum a security threat just to get the leverage they wanted for the USMCA negotiations. It was absurd. It was insulting. But guess what? It worked. They bogged the courts down in deference arguments, they forced Canada and Mexico to the table, they extracted concessions, and by the time the legal dust settled, the policy goals had already been achieved. Jamieson Greer's comments yesterday are just the sequel to that same strategy. It is the throw everything at the wall approach to governance.
They don't start with the law and ask, what are we allowed to do? They start with the desire, we want tariffs, and then they work backward, grabbing whatever statute happens to be lying around. Today, it's IEEPA. Tomorrow, it's Section 301. Next week, it's Section 122. If they could justify tariffs using the Endangered Species Act, I guarantee you they would try it. And notice what this does to the very concept of checks and balances. The Constitution, that dusty old document they love to sell branded Bibles of, is extremely clear. Article 1, Section 8. Who has the power to lay and collect taxes, duties, imposts, and excises? Congress. Not the president, not the trade representative. Congress. For 200 years, if you wanted to change the tariff schedule, you had to pass a bill, you had to debate it, you had to get votes, you had to compromise. What Greer is describing is the final death knell of that system. They have discovered that if they just keep chaining together emergency powers and unfair trade investigations, they can effectively legislate from the White House without ever consulting a single member of the House or Senate. They are bypassing the legislative branch entirely. And when Greer stood there at the Atlantic Council and talked about closing loopholes, did you catch the irony?
What he calls a loophole is what the rest of us call the law. A company suing because the president exceeded his authority isn't using a loophole. They are exercising their constitutional right to due process. But in the eyes of this administration, any law that restricts their power is a technicality, a glitch, a loophole that needs to be soldered shut with a backup plan. This creates a terrifying new reality for everyone, not just corporations, but you and me. It weaponizes uncertainty.
Markets crave stability. Businesses need to know what the rules are so they can hire people, buy inventory, and set prices. But the Trump administration thrives on chaos. They want the uncertainty. They want every CEO in America waking up at 6 a.m., checking their phone, terrified that the rules have changed overnight. Why? Because when the rules are clear, you have rights. When the rules are chaos, you have to beg for mercy. If the tariff authority is constantly shifting from IEEPA to 301 to 122, then the only constant is the president's will. You can't rely on the law to protect you because the law changes every time they lose a court case. You have to rely on their benevolence. You have to lobby them. You have to flatter them. It turns the United States economy from a system of laws into a system of patronage. Greer's admission is the quiet part out loud moment for this entire philosophy. He is telling us that they view the Supreme Court not as a co-equal branch of government, but as an annoyance to be managed, a hurdle to be jumped, a pothole in the road. He is confirming that they have no intention of ever letting go of these tariffs, regardless of what any judge, jury, or statute says. They have decided that this is the new normal, and they will bend, twist, and break every remaining norm in Washington to keep it that way. And if you think this stops at trade, if you think this backup plan mentality applies only to import taxes, then you haven't been paying attention to the trajectory of the last decade. Because once you establish that the executive can simply switch authorities to ignore a Supreme Court ruling, you have opened a door that you cannot easily close. So where does this leave us? We are standing at the edge of a precipice, and Jamieson Greer just told us that the administration is planning to jump, regardless of whether they have a parachute or not. If we allow this backup plan mentality to become the standard operating procedure for the United States government, we are entering a post-legal era. That sounds dramatic, I know, but look at the evidence. We are talking about a scenario where the Supreme Court, the supposed final arbiter of what is legal in this country, could issue a ruling saying stop, and the executive branch's response is not compliance, it is evasion. If they pivot to Section 301 or Section 122 the moment the gavel drops on learning resources, they are effectively declaring that the president's policy preferences override the law. They are saying that the emergency is whatever they say it is, and the authority is whatever paragraph in the U.S. Code they haven't burned yet. Do you understand what that means for the future? If they can use a backup plan to bypass the Supreme Court on trade, what is next? What happens when the Supreme Court strikes down an immigration policy? Do they just find a backup plan in the health code? What happens when the court strikes down a surveillance program? Do they find a backup plan in the Patriot Act? What happens when they want to seize property or suppress speech or rewrite election laws? Once you establish the precedent that a Supreme Court loss is just a temporary setback that can be fixed with a different memo, you don't have a constitutional republic anymore. You have an elected monarchy. You have a king who rules by decree, supported by a team of lawyers whose only job is to find the loophole that justifies the king's will. And let's not forget who pays for this arrogance. You do.
While Greer and the Atlantic Council folks sip their coffee and talk about revenue recreation, the American consumer is the one footing the bill. Tariffs are taxes, period. When they scramble to keep that $200 billion flowing, they aren't taking it from China, they aren't taking it from Mexico, they are taking it from the single mom buying sneakers for her kid. They are taking it from the contractor buying lumber. They are taking it from your 401k. They are fighting tooth and nail, shredding the Constitution in the process just to preserve the right to make your life more expensive.
And the most terrifying part? The markets are starting to price this in. Wall Street isn't reacting with horror, they are reacting with resignation. They are adjusting their spreadsheets for a world where the rule of law is a variable, not a constant. They are realizing that in Trump's America, the only law that matters is the one coming from the resolute desk. This is the end game. The end game isn't about steel or aluminum or cars. The end game is total executive discretion. The goal is a system where Congress is a debating society with no power, the courts are a nuisance to be bypassed, and the president has the absolute unchecked authority to reshape the American economy on a whim. Jamieson Greer didn't just outline a trade strategy yesterday, he outlined a roadmap for how to dismantle the checks and balances that have held this country together for 250 years. He told us, calmly, politely, that they have a plan to win even if they lose. So the question is no longer, will the Supreme Court stop them? We know the answer. Even if the court tries, the administration is already packing the getaway car. The question now is, will we accept it?
Will we accept a government that treats the law like a suggestion? Will we accept an administration that views the Supreme Court as a speed bump? Will we normalize the idea that the president can tax us into oblivion based on statutes that don't apply simply because he refuses to take no as an answer? We have to stay loud. We have to keep the receipts. We have to call this what it is. It's not a backup plan, it's a breakdown. And if we don't demand accountability now, if we let them seamlessly switch from IEEPA to Section 301 without so much as a whimper of protest, then we are giving them permission to do it again and again and again. The mask is off. They told us the plan. Believe them.